My name is Paul Wolfson. I have the job of moderating the discussion this afternoon. I'm a partner at WilmerHale here in Washington, D.C., in our appellate and Supreme Court litigation group. And we have a great panel for you this afternoon. To my immediate left is Daniel Tokaji, who is Associate Professor at the Ohio State University's Moritz College of Law. Daniel's scholarship addresses questions of political equality, racial justice, and the role of the judiciary in a democracy, with particular focus on election law and administration. Before arriving at Ohio State, Daniel was a staff attorney at the ACLU of Southern California, where he litigated many civil rights and civil liberties cases. To Daniel's left is Eve Gartner. Eve is the Deputy Director for Public Policy Litigation at the Planned Parenthood Federation of America. And Eve argued Gonzalez versus Carhart, a very famous case to most people in the audience involving the challenge to the Nebraska partial birth abortion law.
Actually, the federal.
Oh, that was the federal one. I'm sorry, the federal one. Yes, okay. My apologies for Planned Parenthood. Oh, that was Stenberg versus Carhart.
Yes.
To Eve's left is Steve Shapiro. Steve has been the National Legal Director for the ACLU since 1993. And Steve Shapiro oversees all of the ACLU's work in the U.S. Supreme Court, and he is also an adjunct professor at Columbia Law School, where he teaches on civil liberties and the response to terrorism. And finally, we have Roger Pilon, who is really his area of expertise covers the waterfront. Roger is Vice President for Legal Affairs at the Cato Institute, where he also holds the B. Kenneth Simon Chair in Constitutional Studies. And he is the founder of the Cato's Center for Constitutional Studies, the publisher of the Cato Supreme Court Review, and an adjunct professor of government at Georgetown University, and has awards and honors too numerous to mention in this setting. We're going to have what I hope is going to be a very lively discussion this afternoon. I'm going to start off by letting Daniel and then Eve talk a little bit about, to start the discussion by talking about challenges to constitutional litigation in their particular areas of expertise, which are, in Daniel's case, sort of election law and voting rights law, and in Eve's case, reproductive rights. And we're going to have a lot of discussion this afternoon, I think, about two topics in particular. The first topic is the emergence of this important distinction that the Supreme Court is driving home between facial challenges and as-applied challenges, and what this means for bringing effective challenges to the constitutionality of restrictive legislation. We're also going to have a discussion about the Supreme Court's recent decision in Ashcroft versus Iqbal, which, for those of you who have not read it, is a very, very important decision involving pleading standards, and we're going to be talking about that quite a bit. And Steve, I think, is going to be sort of starting us with that discussion. So to get the ball rolling, I will hand the matter over to Daniel, who will talk to us for a little while. And go ahead.
Okay. Well, so the focus of this panel is on barriers to access to court, to getting into court on constitutional claims and getting relief on constitutional claims. I'm going to talk about this in the context of my primary area of expertise, voting rights and election law, where in recent years we've seen an increasing reluctance on the part of the Supreme Court to entertain facial challenges to electoral laws and other rules. Now, before getting into this, I think it's helpful to spend a few moments putting this facial as applied doctrine in the context of the other barriers to constitutional litigation that have been created and developed in recent decades. And when I teach Fed courts in my law school classes, it reads like a list of the barriers to constitutional relief that were developed, if not invented, during the Rehnquist court years, going from standing and justiciability to sovereign immunity, abstention, absolute immunity, qualified immunity, and let's not even start on habeas, right? In all of these areas, the Rehnquist court generally made it more difficult for people to get into court or to obtain certain forms of relief on constitutional claims. Well, with the court's, I won't say new, but greater emphasis on the facial as-applied distinction and its reluctance, especially in election cases and abortion cases, to grant relief striking down laws on their face, we at least arguably see one more manifestation of these barriers to access to court. Let me talk for a few moments about the facial as-applied distinction, what it is generally, and then how it's played out in voting and election cases. So what is the distinction? Well, when we're talking about facial challenges, and they've been defined in different ways in different cases, but what a litigant, plaintiff is seeking to do is to strike down a law on its face, meaning in all of its applications. Now, there's a case from several years ago, the Salerno case, which sets a pretty high standard for obtaining facial invalidation of a statute, saying that relief should only be granted if there's no set of circumstances in which the law could constitutionally be applied. In other cases, however, especially First Amendment cases, the court has generally been more generous in allowing facial challenges. The rationale, at least in the First Amendment context, and I think to a considerable extent in the abortion context as well, as Eve will discuss, being that we don't want to chill constitutionally protected activity. So sometimes we may strike down an overbroad speech regulation or an abortion law because even though some applications may be okay, we're really worried about discouraging or chilling constitutionally protected conduct like speech or the right to obtain an abortion. Well, in recent election cases and voting cases, the court has been quite insistent on harping on this distinction and in being very stingy when it comes to striking down election laws on their face. And I, in all fairness, I think that for liberals as well as conservatives, there is sometimes something to be said for more narrowly tailored relief. One of these cases, and the one that most fully explains the reluctance to grant facial relief, is a case from more than a year ago, the Washington State Grange case. This is a case in which a challenge was brought to Washington's primary system in which the top two, regardless of party, would make it from the primary into the general election. Now, the wrinkle was that candidates could indicate their party preference. They weren't seeking the nomination of their parties, as in an ordinary primary, but they could indicate their party preference. And the Washington State Republican Party challenged this law, saying it was a violation of the party's rights of association. The court in that case declined to strike down the statute on its face, while leaving the door open to future as-applied challenges. Second case, or I should say two cases, are cases challenging the electioneering communications, or so-called sham issue ad portion of McCain-Feingold, the Bipartisan Campaign Reform Act. In the McConnell case, the court declined to strike down the law on its face, again emphasizing its reluctance to grant facial challenges, despite the fact that this was a First Amendment case. In a subsequent case, however, the Washington Right to Life case, the court granted as-applied relief, but as-applied relief that really creates a huge hole in the coverage, saying that this provision can only be applied to campaign ads that are susceptible to no other reasonable interpretation but as an appeal to vote for or against a certain candidate. Third case is Crawford, the Indiana voter identification case, one that I suspect is likely to be of great concern to a lot of people in this room. In this case, the court upheld against a facial challenge the most stringent voter identification law in the country, a law that requires people to show government-issued photo ID in order to have their votes counted. The concern raised by the plaintiff was that this would exclude a lot of people who don't have a driver's license, disproportionately poor people, minorities, people with disabilities, and other disadvantaged groups. Well, the court rejected the facial challenge in that case, while again leaving the door open to as-applied challenges. Now, there are some clear advantages, I think, at least in some cases, to withholding facial relief. One is, judicial restraint. We should, wherever possible, defer to political branches. But there are some downsides, too, especially in the context of voting laws, when we're generally dealing with systemic harms. One of the cases, and I'll conclude with this, that is currently on the Supreme Court's docket and will be decided shortly, is the Northwest Austin Municipal Utility District versus Holder case now. This is the challenge to Section 5 of the Voting Rights Act. Now, if the court is conscientious in applying this facial as-applied doctrine, I think it should actually issue a very narrow ruling, striking down, if it's inclined to do so, the act, and this is what most people seem to think the court is likely to do, as applied to this single municipal utility district, which has no history of discrimination and which, under the act as most people read it, can't get out of coverage, can't bail out. We'll see, and I think one of the dangers of the facial as-applied doctrine is that, like standing, it invites enforcement and implementation in a way that is something less than even-handed. To borrow something Justice Brennan said in the Allen versus Wright case, it invites rulings that are a poor disguise for the court's view on the merits. And I'll stop there.
Eve, you want to pick that up?
Thanks, Paul, and thanks, Dan, for laying out the foundation, so I don't have to do it. So as Dan indicated, federal court challenges to restrictive abortion laws have always been an exception to the general facial challenge rules. The Salerno no set of circumstances test has never been applied to a direct abortion restriction challenge. Instead, at least until recently, the court has applied a test in the abortion context that I believe it applies in no other context. What the court has said is that facial challenges to abortion restrictions can succeed if the law is unconstitutional in a large fraction of cases in which the law is an actual restriction. So under this formulation, in a way, the key question is what is the denominator in the fraction? The challenge can succeed if only a very small number of women would actually be prevented from getting an abortion or extremely burdened in getting an abortion if that group of affected women is a large fraction of the affected women. So the whole question is, who are the affected women? That's the test that the court has been using since Planned Parenthood versus Casey. However, 2 years ago, in the Gonzalez versus Carhart case, the challenge to the federal law on so-called partial birth abortion, the court indicated in a somewhat schizophrenic and perhaps even unprincipled fashion that it was changing the rule. And just to explain that, I just need to go into a little bit of detail about the case. There were 2 separate claims in the case. One that related to the breadth of the statute and how many abortions would actually be banned by the law. That was really a purely legal question. It was a statutory interpretation question, and the court reached that question on the merits, rejected it on the merits, but reached it on the merits, and never suggested that the facial challenge to it was the improper procedural route. The second claim related to the fact that the law lacked a health exception, and our claim that the absence of a health exception made the law flat out unconstitutional under decades of precedent. On that claim, the court also reached the merits and rejected the merits, but at the very end of its merits discussion, almost as an aside, the court said, this facial challenge, actually I just need to look at the language because I want to get it right, this facial challenge should not have been entertained in the first instance. Rather, the court said it should have been brought in an as-applied context, either pre-enforcement or after the law went into effect. Of course, the court did not explain why it reached the merits of a claim that it said was premature. And the court also really didn't address Justice Ginsburg's point in dissent that there really was functionally no difference between a pre-enforcement as-applied challenge, which the court said would have been permissible, and the case that actually was presented to the court, because the record was voluminous in terms of very specific, detailed information of particular cases where the banned abortion procedure would be the best medical choice. So really the only difference between a pre-enforcement as-applied challenge and the facial challenge that was before the court was the remedy that the plaintiffs sought. We sought complete invalidation, but of course the court is free to fashion its own remedy in any case it wants, so really the distinction between facial and pre-enforcement as-applied was almost imperceptible. So taking Gonzalez versus Carhart, there's no doubt. We don't know exactly what it means because the court dealt with 2 different claims in different ways, but clearly the bar has been raised for bringing facial challenges to abortion restrictions. And I just want to outline a couple of the ways in which this newly raised bar raises very specific practical problems for those of us who spend our lives trying to protect women's access to abortion rights around the country. The first issue is one of timing, especially if an as-applied challenge really needs to wait until a law goes into effect so that the plaintiffs can build the record about the particular harms. Obviously, when a woman decides to have an abortion, she wants to be able to, and really needs to be able to access that medical care quickly, and isn't about to commence a federal court lawsuit and wait for that to play itself out. So the timing issues weigh heavily against as-applied challenges. The second, as Dan alluded to, is the chilling effect. And there's actually 2 components to the chilling effect. There's the chilling effect on doctors. If almost in all cases, restrictive abortion laws are criminal laws with felony penalties. And most doctors in this country can do other things with their lives besides providing abortions. They have skills, and they're not so inclined to take the risk of a felony conviction by violating an abortion restriction. So there's a real risk that doctors will simply stop providing the medical care that might in any way violate the statute instead of challenging it in federal court. And the obvious result of that is that women will be denied that care. And then the second component to the chilling effect, again, is the woman herself. how many women wanting a particular medical service will want to go to federal court to vindicate her right to that service, as opposed to driving a long distance to go across a state line, going on the internet and illegally buying medication that might induce the abortion, or simply giving up and carrying the pregnancy to term. So I think, the real problem is that the women who are truly affected by restrictive abortion laws are likely simply to disappear. They're not going to find their way to a lawyer. They're going to make do the best that they can. The third real concern relates to remedy. And clearly, part of what underlies the court's discomfort with facial challenges is its discomfort with facially invalidating a statute that might have some legitimate or constitutional applications. But in the abortion context, how can the court possibly craft limited relief? When you think that most abortion restrictions that the unconstitutional burden is going to weigh most heavily on low-income women, women who travel long distances to get to one of the very few abortion providers in the state, to uneducated women, how is the court going to draw the line about who is unduly burdened by the restriction? Will it be based on income? Will it be based on how far they have to travel? I mean, these lines make no sense in a constitutional perspective, and we can't even imagine an injunction that says this law is enjoined as to women who must drive over 200 miles to an abortion provider. And what about the woman who drives 197 miles? Or what about the woman who needs an abortion because her blood pressure is excessively high and continuing the pregnancy will endanger her health? Well, what about the woman whose blood pressure is just ever so slightly lower? The line drawing just seems unworkable if you take it out of the facial invalidation context. And then quickly, the fourth real concern relates to the fact that abortion challenges have, for the most part, since Roe, been brought using a doctrine called third-party standing, where the actual plaintiff in the case is not the woman herself who's seeking the abortion, but is her doctor or the clinic where the abortion would be performed. And in that context, even if the case was brought in an as-applied context where the court is under the impression or is indicating that it thinks it will have more specific facts at its disposal, it's not really the case where you have third-party standing. If a doctor is representing all of his or her patients, the court isn't going to have the specificity that it thinks that it's going to get in an as-applied challenge. And so it raises the question of whether the next step for the court is to say it's not going to permit third-party standing in this type of constitutional context because it really wants to see the particular facts of each woman and why she believes that this law is a burden on her. So all of these are challenges looking forward in this particular area of the law.
Thank you, Eve. Thanks very much. We're going to get back to this issue most definitely. But Steve, let's shift gears just a little bit and talk about another new challenge to constitutional litigation, which is the Supreme Court's apparent tightening of the pleading standards in the two recent decisions of Twombly and Ashcroft versus Iqbal. And we'll discuss the facts of the case a little bit, but the court threw out the old no set of facts standard of Conley versus Gibson and instead seems to have insisted that a claim of a constitutional violation showed that the violation actually be plausible or credible on the facts alleged and not merely possible. And I guess my questions to you are, how important is this decision, or are these decisions really? Do they have real bite? Is this just a clarification of where we were, or are we into sort of a completely new world now?
Well, thank you, Paul. Let me begin with a few prefatory remarks. First, I was struck when I noticed that the title of this panel was New Challenges to Constitutional Litigation. I don't know if this will make people in the room feel better or worse, but constitutional litigation has always been challenging. Except
We'll have this panel every year, actually.
Except maybe for a brief shining decade from 1963 to 1973. And then I began to worry as I was thinking about what I would say about how to discuss these issues without discouraging a room full of law students and young lawyers. And so I do think it is worth saying at the beginning that there have always been challenges. There are new challenges that we can discuss. But at least at the ACLU, we continue to win a very high percentage of our cases, far more cases than we lose. And so you can listen to a panel like this, I think, and walk out of the room thinking it's impossible ever to win a case. That is hardly the situation. And so I hope at the end of this discussion you will all still leave the room thinking that you want to pursue careers as civil rights and civil liberties lawyers. My other comment is I have to say I was very inspired listening to Elizabeth Warren at lunch today, and I came out of that talk thinking with a brilliant idea. I thought what we need is a constitutional rights protection agency in Washington. That I used to think that was the Supreme Court, but I'm not.
I thought that was the ACLU.
Yeah, right. We don't take government money. And then my final comment, which has nothing to do with anything, it just, it struck me. I don't know if anybody else had this experience, but I was downstairs this morning listening to the Constitution 2020 lecture, and I walked out to go to the bathroom, maybe more detail than you want to know. And, but on my way to the men's room, I passed another room next to the room where the Constitution 2020 session was called, and it's labeled. It's got a little sign outside. It says the Constitution Room. And the Constitution Room, I cannot tell you how small it was. Maybe 12 people could have fit into it, and I thought this is a bad sign for an ACS conference. All right, Iqbal. Let me just begin very, very quickly with the facts which may be known to many or most of you. Iqbal is an Arab American who was arrested in November 2001 as part of a nationwide sweep by law enforcement agents, which ultimately led to the detention of somewhere around, to the extent that we know, somewhere around 1,000 Arabs and Muslims throughout the country, some of whom were picked up and detained on immigration charges, and some of whom, like Mr. Iqbal, were picked up and detained on criminal charges. He was charged and ultimately pled guilty to a possession of false identification documents, false immigration documents. After his detention, he was put into the Metropolitan Detention Center in New York, where he was ultimately designated as a person of high interest, which resulted in his confinement in a special segregation unit, where the conditions were quite harsh and where he ultimately alleged that he was abused in various ways, physically and otherwise, during his detention. He then sued a whole bunch of people, including some known and unknown corrections officers in the correction facility, the warden of the detention center, and for purposes of this story, Bob Mueller, who was the director of the FBI, and John Ashcroft, who was then Attorney General of the United States. And he claimed that he had a series of legal claims in his abuse, but the overarching theory of his complaint was that he was singled out for arrest, detention, and mistreatment because he was Arab and Muslim, and that governmental action violated his rights under the First and Fifth Amendment because it constituted discrimination on the basis of race, religion, and national origin and ethnicity. Mueller and Ashcroft filed a motion to dismiss claiming qualified immunity. And the essence of the motion was that even if you accepted the allegations of the complaint as true, they did not establish that these two defendants in particular had violated any clearly established constitutional rights. While the case was working its way through the lower courts, the Supreme Court decided AT&T versus Twombly. Between the district court decision in the case and the Second Circuit decision in the case, I won't begin to try to explain Twombly. Twombly is the predecessor to Iqbal as a pleading issue, but substantively it's an antitrust case, and what do I know about antitrust law? Nothing. But Iqbal gets to the Second Circuit, and the Second Circuit says, notwithstanding Twombly, which introduced, and I'll come back to this in a moment, the plausibility standard for judging the sufficiency of pleadings, notwithstanding Twombly, the Supreme Court said, the allegations of this complaint contain sufficiently specific information about Mueller and Ashcroft, then the case can go forward, that it would be inappropriate to dismiss it on a motion to dismiss. And while we are very sensitive to the problems that can arise when high government officials are sued and subjected to discovery, which can distract them from their other duties based upon complaints that may be thin on their face, we have confidence in the district court judge to, among other things, structure discovery so that he can require the plaintiffs to begin discovery with lower government officials and then only move up the chain as appropriate after discovery has been completed. Mueller and Ashcroft then take the case to the United States Supreme Court, and the United States Supreme Court, by a 5-4 vote, dismisses the complaint, grants the qualified immunity motion filed by Ashcroft and Mueller. And the court really does four things. One is the opinion is written by Justice Kennedy. There is a little discussion at the beginning about whether or not the Court of Appeals even had jurisdiction to hear the appeal, because it was an interlocutory appeal. There was not a final judgment. There are certain circumstances in which you can take an immediate interlocutory appeal on a qualified immunity question, and other circumstances in which you cannot. We don't have to go into the sort of details about what's on what side of the line and what's on the other side of the line. I raise it only because, in my view, there was a very, very legitimate argument that this qualified immunity decision by the district court judge should not have been appealable at all. And the jurisdictional decision the Supreme Court made in Iqbal that it was appealable, like many of these facial and as-applied challenges, like many of the other standing doctrines and mootness doctrines, are in fact very malleable doctrines. And I think one of the concerns that many people have that litigate before the Supreme Court is that the Supreme Court manipulates those doctrines in a result-oriented way. And I think that was true of the jurisdictional decision in Iqbal. If they didn't want to hear the case, they didn't have to hear the case. They wanted to hear the case because they wanted to reach the result that they ultimately reached. The second thing the court said before they ever even got to the plausibility standard is Iqbal, because he was suing federal agents, he wasn't suing state and local government officials, had to rely on something called the Bivens Doctrine. There is no statute on the books, federal statute, that allows you to sue federal government officials for the violation of your constitutional rights. Instead, that is a judicially created doctrine by the Supreme Court in a case called Bivens versus six unknown agents. And the court for a long time has been saying, we don't like Bivens actions very much, and we are very reluctant to expand the category of cases in which people can sue federal government officials for violation of your constitutional rights. And they then say, it is an open, we have held in the past that you can bring an equal protection claim under Bivens if you are alleging race discrimination. We have never held that you can bring a free exercise claim alleging religious discrimination under Bivens. The federal government doesn't seem to be challenging that here, and so we will assume that you can bring a Bivens action based upon alleged racial discrimination and proceed with the case based on that assumption, but we're not deciding it. right? So it was one of those little sentences that get dropped into Supreme Court opinions that then become a signal, first of all, to defendants and ultimately to lower courts, that rights and rights protection that previously I think would have been taken for granted. Most people would have assumed there was not a serious question about whether you could bring a religious discrimination claim under Bivens against a federal official, all of a sudden has been called into play, not in Iqbal, but in the cases that will follow Iqbal. The third thing that the Supreme Court said as a setup to its plausibility is they said, well, you're not claiming, Mr. Iqbal, that Mueller and Ashcroft actually did anything to you. You're not claiming that they made the specific decision to designate you as a person of special interest. You're certainly not making the allegation that they were involved in, personally engaged in any physical abuse. Your claim against them is based upon some notion of supervisory liability. And we have held in the past, both in Section 1983 cases and in Bivens cases, that liability for constitutional violations cannot be based upon a notion of respondeat superior. You have to be able to directly tie each named defendant, right, to your alleged constitutional wrong, and you need to be able to show ultimately that each named defendant caused the constitutional injury that you claim that you suffered. They then go on to say that because you are alleging, and what the allegations of the complaint said, in effect, was Mueller and Ashcroft were supervising, especially in November 2001, the government's post-9/11 law enforcement activities. And Mueller and Ashcroft directed that those activities be focused on the Arab and Muslim communities in the United States. This is what the complaint alleged. And they were closely monitoring the progress of that law enforcement operation, anti-terrorism operation. And so they were regularly receiving reports about how many people were arrested and who they were and where they were being held, and therefore they, at the very least, knew what had happened about the general, in a general sense. They knew about Iqbal's arrests and detention and the fact that he was Arab and Muslim, and that this was part of a broader program to round up Arabs and Muslims in the United States. And at the very least, they acquiesced in that, right? And that makes them responsible for the constitutional injury. The Supreme Court then says, no, it doesn't. They say, in order to establish Bivens liability on a discrimination claim, you must show more than knowledge, you must show purpose, a discriminatory purpose. And you have not alleged a discriminatory purpose, which jumps over the fact that often when you don't have a smoking gun, the way you prove discriminatory purpose is by building on an inference that begins with knowledge, right? And so there's very troubling language in this opinion about the scope of supervisory liability before you even get to the pleading question, all right? Now you get to the pleading question. And so they have set this up by saying, we'll assume there's a Bivens claim here, although we're not really convinced of it. But in order to establish the Bivens claim, you have to allege more than knowledge. You have to allege purpose. So let's look at what you have alleged against Mueller and Ashcroft. And the opinion goes on to say, well, what you alleged is post 9/11, they sent out a very clear signal, if not direction, that they wanted to focus law enforcement attention on Arabs and Muslims who were living in the United States, right? And they made it very clear that they would pick people up on any charge they could. It didn't have to be a terrorism-related charge. And then they would figure out later whether anybody had any terrorism-related connections. And so the Supreme Court looks at that and they say, well, the test we now know from Twombly is no longer whether, assuming those allegations, there is any set of facts that you might be able to develop during discovery that would establish that those facts constitute a constitutional violation. Instead, post-Twombly, the question is, looking at the complaint on its face, accepting your factual allegations as true, discounting your legal conclusions because they're not entitled to any weight at all, have you plausibly alleged that Mueller and Ashcroft acted with an invidious discriminatory purpose? Right? Plausibly alleged before any discovery has been taken. No discovery has been taken, right? And the question that just leads to, of course, is, well, what does it mean to say, have you alleged a plausible claim? So Justice Kennedy said, as Justice Souter said in Twombly, plausibility does not mean probability. Doesn't mean that it has to be more likely than not on the face of the complaint. That's your ultimate burden of proof after trial. That's not the burden of proof at the pleading stage. Well, then what is it? He says, well, it's got to be more than conceivable. Less than probable, more than conceivable, right? And he then says, in what I think is the most troubling passages, he says, the plaintiff looks at these facts, right? This roundup of Arabs and Muslims post 9/11 and says, this is racial and religious discrimination. A more likely explanation, quote unquote, says Justice Kennedy, a more likely explanation, without any discovery in the case, is that the 19 people who hijacked the planes on September 11, 2001, were all Arab and Muslim. And therefore, it makes perfect sense as a law enforcement strategy to focus your law enforcement resources on the Arab and Muslim communities, because that's where the hijackers come from, although they were not domestic hijackers. And even if that law enforcement strategy had a disparate impact on the Arab and Muslim community, disparate impact does not translate into a constitutional showing of invidious discrimination. And because it is more likely that this was motivated by law enforcement concerns than by invidious discrimination, you have not met your burden of proof, and therefore the case was properly dismissed at the outset before any discovery. And so in answer to your question, Paul, how big a sea change is this going to be? I think the answer is we don't know yet, because we don't know how the lower courts are going to interpret this. What I can tell you is in our cases, we are seeing, in many of our cases, government officials, government defendants filing motions to dismiss based on the theory that the allegations of the complaint do not plausibly lead to any constitutional violation, because there is a more likely explanation, namely that the defendants were acted lawfully, a determination that I would have thought is more properly made after the trial, rather than at the pleading stage. I am not troubled by the part of the opinion that suggests when people draft complaints, even though we've had notice pleading since 1938, it's not about, you're not supposed to be tricking people. We're not back to the field codes. If you don't use the right words, your case gets thrown out of trial. That shouldn't be what it's about. But I'm not troubled by the notion that if you file a complaint, you ought to have more than merely conclusory allegations. You ought to do more than simply restate the elements of the claim that you are alleging and then say, ergo, give me money or give me my injunction. I think you ought to have some facts before you go into court, and if you have some facts, generally speaking, you ought not to be reluctant to allege them. But the notion that judges, right, before discovery, before trial, based on the face of the complaint, can make a decision about what is or is not plausible on a standard that is not explained and appears to me to be entirely subjective, I think it's more likely that these defendants were acting for good reasons than bad reasons. That seems to me a substantive change in constitutional law in the guise of a pleading decision. And so if Iqbal, if the lower courts read Iqbal as really allowing now a free-range inquiry into plausibility at the motion to dismiss stage, I think we're in for some really difficult times. If the way they read Iqbal is simply to say, I want to see some meat on these bones in your complaint, I want to see some facts, I don't want to see a complaint that simply says, I'm Arab, I'm Muslim, I was arrested by the federal government, and therefore I must be the victim of discrimination, that's not enough. That doesn't bother me so much. And I think we're just not going to know for a while about how this is going to play out.
Thanks very much, Steve. It's a very interesting case, and I think we'll be seeing a lot of litigation about it, as you say. Roger, you sometimes look at these issues from a different perspective. In particular, you've written extensively about the importance of keeping Congress to its enumerated powers. And a question I have for you is, do you think that these new approaches will carry over into that area where people are challenging a congressional statute as exceeding Article I powers or the powers granted in the Civil War amendments? And do you think that this new approach is it justifiable judicial restraint, or is it really just a content-based hostility to the rights that are being asserted?
Not only do I think that they will carry over, they already have carried over, as I will explain in just a moment. I want to first begin, though, by commenting on Steve's observation right at the outset that what we might need is a constitutional rights protective agency. If that agency works as other agencies here in town, he might be careful about what he asks for, because I think they're doing a better job than such an agency would do.
We win either way, Roger. Either we get rights protected or we get more work for the ACLU.
That's right. Lawyers, full employment, ever the agenda. Okay. Let me say, first of all, that I've spoken many times in this room for the Federalist Society. It's good to be back here, I think, because 2 years ago I was invited to be something of a contrarian. I assume that that's what I'm invited here for today, too, and I hope I don't disappoint my guests, my hosts in saying that. As both Paul and Dan mentioned at the outset, we're focused on this panel on obstacles that have arisen in recent years in bringing constitutional claims in federal court. And in particular, although it's early in its tenure, and the Roberts Court especially has seemed to disfavor facial constitutional challenges, preferring as applied challenges, reflecting perhaps the judicial restraint preferences of the conservatives on the court, or if you prefer, the judicial minimalism of the liberals on the court. I know of no study that has been done, empirical study of just what the numbers are on this. The evidence is mixed and it's skimpy so far. It's limited, especially in the Roberts Court, drawn mainly from voting and abortion cases, as we've seen thus far. But I'm going to suggest that the deeper problem is that there seems to be no pattern to what the court is doing in this, as in so many other areas of its jurisprudence. And I'm hardly alone in thinking that. Recall Larry Tribe's green bag essay of a few years ago explaining why he wasn't going to complete a new edition to his con law treatise. He could see that the pudding had no theme, to put it in Churchillian terms. But in the course of thinking about this subject, I came across an essay that does try to order it. It's by David Franklin, who teaches at DePaul Law School. It's not out yet. It's due out in the Hastings Constitutional Law Quarterly. It's entitled Looking Through Both Ends of the Telescope, Facial Challenges and the Roberts Court. And I commend it to those of you who want to look at a more systematic approach to these issues. And I'm going to draw from that in the course of my remarks. Franklin begins by distinguishing two paradigms. He says at the outset, consider this statement, constitutional adjudication is always as applied. In the next paragraph, he begins, now consider this, constitutional adjudication is always facial. He says that what we actually end up with is neither of those, but sometimes one, sometimes the other, hardly surprising. But in distinguishing these two, he draws out some important differences between the two, in addition to the ones that Dan pointed out. For example, and most importantly for my purposes, he speaks of, as applied, as dealing mostly with rights cases brought before the court, and the facial challenges as mostly dealing with powers cases brought before the court. With respect to the as applied, he says that the plaintiff is claiming that he's entitled to certain relief, whether the conduct of the party bringing the challenge is protected by a valid claim of constitutional right is the issue. He says the rights serve as shields. A ruling that vindicates a constitutional right, however, does not strike any law. By contrast, when you've got a facial challenge, it's not so much a rights challenge in most cases. It's rather a challenge to the very statute itself to determine whether the challenger's conduct is regulated by a constitutionally permissible law. And he says that it's a purposes and effects test of the statute. According to the applicable doctrinal tests, rarely do rights in these contexts function as shields. And then he concludes, as I said, that most of this is substantive at the end. He says, by the end of our exploration of the court's recent cases, we'll have discovered that substantive doctrine is what causes the justices to look at constitutional adjudication through both ends of the telescope, that is to say, the as applied as well as the facial. And toward the end of his essay, he concludes, with respect to the question immediately before us, that the Roberts Court indeed follows the traditional model of judicial review, which is as applied model. It's alive and well on the court, and he cites cases like Aote and Carhart, as Eve has done. He says that nonetheless, the court has strategic uses for the traditional model, and he comes up with a third category, which he calls facial adjudication in as-applied clothing. Again, he concludes, however, that the most central issue here is the substantive constitutional doctrine. Okay, I'm going to use that as my point of departure here, and I want to take that point about substantive constitutional doctrine a bit further, if only an outline, because I think it goes to the heart of the matter. To do so, however, I'm going to have to sketch a few first principles, starting with the Constitution itself, of course. Purporting to be the supreme law, the Constitution, of course, authorizes certain delegated powers. It recognizes other state powers. It checks and balances those structurally. A Bill of Rights, enumerated and unenumerated, was added 2 years later to check the exercise of the enumerated powers, and the 14th Amendment completed the Constitution, so to speak, by applying those rights against the states. Finally, the document provides for adjudication of all of this through cases brought before the courts. But what's the presumption? Is it liberty or is it power? Let me suggest that that's where the problem before us begins. In the hoary old days of Lochner, dare I say, the presumption was with liberty. But with the progressive era, in which most of you in this room, I assume, find your roots, the presumption switched, and the New Deal court constitutionalized that switch. Early in the 20th century, the scope of state power vastly expanded. At the federal level, the 1937 court jettisoned the doctrine of enumerated powers. A year later, it bifurcated the Bill of Rights, rendering most rights like poor relations, as Justice Rehnquist put it colorfully in the 1994 case of Dolan v. City of Tigard. Returning to Franklin's thesis, then, and adding to it this brief history, once you're working with a strong presumption of constitutionality, as we are today, that means that facial challenges concerning powers face an uphill battle. Indeed, it was not until 1995, some 58 years after the constitutional revolution of 1937, that we saw a successful challenge to Congress's otherwise unlimited commerce power. I allude, of course, to U.S. v. Lopez and, of course, to Morrison 5 years later. And where were the liberals on those minuscule checks on Congress's regulatory power? Screaming in dissent that the world as we knew it was coming to an end. If you think I overstated, go back and read the dissents. Indeed, look at the congressional hearings that were called by the sainted Senator Schumer after the Senate switched parties in 2001. Did he call for hearings for the 11 nominees that had been named by President Bush? No, he called for 3 hearings on various aspects of constitutional theory, including the Rehnquist Court's new federalism. But by the time we reach the Raich case, In 2005, that's the California medical marijuana case, you may recall, even some conservatives ever concerned about judicial activism had become concerned about their apostasy, and so Raich, notwithstanding that it was a challenge to the scope of Congress's commerce power, was treated as an as-applied challenge. That was doctrinal error, I submit, because the proper question, as in Lopez and Morrison, was whether Congress, under the Commerce Clause, had power at all to regulate activity that was neither interstate nor commercial. Reaching back, indeed, beyond the bizarre rationale of Wickard v. Filburn, remember that was the farmer with the wheat case, the court concocted a theory that only a drug lawyer would love. As I said to Randy Barnett after oral argument, he argued that case. I feared that the conservatives would throw Angel Raich to the wolves in order to save the war on drugs, and that the liberals would do so in order to save the modern regulatory state. And of course, that's exactly what happened, except for Rehnquist, O'Connor, and Thomas. And so we have in Raich an example of what Franklin calls facial adjudication in as-applied clothing. Not to strike or limit the scope of a statute, but to vindicate it, what Franklin calls facial vindication. But what justifies the court's as-applied approach here, unlike in Lopez and Morrison? Justice Stevens reasoned that narrow, single-subject federal statutes like those criminalizing guns at school might fall wholly outside Congress's commerce power, but where Congress establishes a comprehensive regulatory scheme, then it can regulate any part of that scheme. But there we have substantive theory, once again, about the scope of the commerce power in this factual context. And so the question whether the court is taking a facial or an as-applied approach may not matter that much, because it's the court's substantive theory and the facts that are doing the work. Turning very briefly to the right side of things, here it seems to me that most cases of adjudication are properly as-applied. Once you've determined, that is, that a power is authorized and its scope is clear, at least at a general level, then whether that power is exercised consistent with retained rights, whether enumerated or not, or even with statutory rights, is a factual determination. Paul asked me before we went on to say something about regulatory takings. Take the famous case of Lucas v. South Carolina Coastal Council in 1992. There's no question that the state had the power there to enact the Beachfront Management Act. Thus, consistent with Franklin's thesis, the court didn't strike the act. Rather, it said that the effect of the act was to render Lucas's property worthless, even though he retained title. And so it had effectively taken his property, requiring payment compensation under the Fifth Amendment's takings clause. In another case, a regulation might have enhanced the value of property, but only an as-applied challenge is appropriate for determining that. There's far more to be said on this case and about other rights cases more generally, of course, but not in the 5 minutes or so that I've got. Most particularly, even if most rights cases are better treated as an as-applied way, there will always be room for facial challenges too, which is why Franklin doesn't draw anything close to a bright line between his two paradigms. The deeper problem, however, concerning the issue before us is just this. If you're going to have as much government as we have today, with the demise of enumerated powers doctrine and the expansive reading of state police power, note both liberals and conservatives share in that, and you're going to combine that with a strong presumption of constitutionality, then you're going to have far less scope for facial challenges and far greater as-applied adjudication. It has less to do with judicial activism or restraint than with your conception of the Constitution. I, for one, would like to see far more facial challenges than we do see, but that's going to take a change in our underlying presumptions from constitutionality to liberty.
Roger, thank you. That's quite a challenge, I think. And Steve, maybe you could pick this up. Certainly there are lots of cases that the ACLU is involved in where you're defending statutes against constitutional challenges. I mean, Section 5 of the Voting Rights Act is an excellent example. I know you're not defending BICRA, but Dan, the BICRA is an example of where a lot of people in this room support the constitutionality of a legislative enactment, and indeed That may continue if the Obama administration tends to be pro-regulatory, and that regulatory agenda may come under challenge from people who are challenging it. So is this is the Roberts Court giving progressives a gift in some areas?
Not intentionally. But I just wanted to make a slightly different point, and that is we use these terms facial and as applied as though there were some recognized and universal understanding of what they mean. And the truth is there isn't, and they are used in different contexts to mean different things. And I just wanted to give, Eve raised, from a litigator's point of view, Eve raised exactly the question that litigators ask when you get a decision like Gonzalez versus Carhart, and that is, well, what am I supposed to do now, right? And the same question arose after the Indiana voter ID law, Crawford, which was a joint ACLU was co-counsel in the case with Paul Smith, the former chair of the board of ACS, so it was a real family affair. And the court says that it was a pre-enforcement challenge, which is also a factor that gets sort of thrown into the mix here. And what the record showed, I think, in a way that couldn't seriously be disputed. There was a dispute about the exact numbers, but there were significant numbers of people, tens of thousands of people, voters in Indiana, who did not have the identification that the state now said was required in order to vote, and those voters who lacked the required ID were disproportionately poor, minority, older, and people with disabilities. I do not think that there was any serious dispute about that. The case goes up to the Supreme Court, and the Supreme Court says, well, you haven't produced a single person who was actually denied the right to vote. And therefore, your allegation that this will have an impact on people's voting rights is purely speculative. And the government on the other side has offered this interest in voter fraud, which was entirely speculative, but the court said nonetheless that interest is enough to trump your interest. Bring this case as an as-applied challenge. Now, an as-applied challenge in that context can mean one of two things. If what the court means is go back, have an election under the Indiana system, figure out how many people actually are denied the right to vote, and then come back, and if there are a substantial number of people, we are prepared to strike down the statute in its entirety, that's one thing. That would seem unfortunate to me because you'd still have to go through one election in which tens of thousands of people were being denied their right to vote, but at the end of the day, the law would be struck down. If instead what the court means by an as-applied challenge, and this was Eve's point, each voter has to come into court one by one and say, I didn't have the requisite ID, I tried to get it, I couldn't get it, they wouldn't let me vote, and therefore my rights have been denied, and my situation is going to be different than the next person's situation. So each person, after the election, when the outcome has been determined, has to take on the time and expense of going to court to get their one vote counted when the election results are already in. That's a very different understanding and meaning of what an as-applied challenge is, and that has a much more serious consequence on your ability to do constitutional reform litigation.
Eve, how does that play out with?
Yeah, I just wanted to add to what Steve is saying, that I think I completely agree that the labels facial and as applied are, it's a moving target. We don't know exactly what they mean, and we don't know what we're supposed to do. But in a way, perhaps even more important than the labels is what I think is really clear when you read Gonzalez versus Carhart and the Crawford case together, is that the court, no matter how the case is brought, the court is imposing just a much more heightened evidentiary standard. I mean, the fact that there was so clearly the evidence in the record in Crawford that some people were going to be disenfranchised as a result of that, and all the court would say really is, well, we don't really know how many. There's a real focus both in Gonzalez and in Crawford on the court's desire for quantification of the constitutional burden. In Gonzalez, when the court said, this shouldn't have been brought as a facial challenge, and it was talking about why an as-applied challenge would be better, the court actually said in the context of an as-applied challenge, we could better quantify the nature of the medical risk, which is sort of incomprehensible to me. It's almost as if the court thinks that there can be like almost a Richter scale of constitutional harm, but that seems to be where it's going. It really wants evidence that it can quantify and pinpoint exactly how many people are harmed. And I think Steve is right. In the election context, that might be more theoretically possible, even if you do have to go through an election cycle to find out how many people voted in one election and then how many people dropped off the rolls in the second, or didn't come to vote in the second election. You might be able to show that was as a result of the voter ID law, though I suspect that this court would say, well, we can't really assume that was why, because in some parts of the state it was rainy that day and that might have been why, or whatever. I think the court is not necessarily going to buy that type of inferential evidence. But again, in the abortion context, it's even harder because, again, if it's impossible, the women that don't actually get abortions as a result of the restriction, it's impossible to know why that is, or to prove, they've disappeared, they've lost their opportunity to exercise their right, and there's no way to do right by them in the future.
Let me make 3 quick points. One is a point of at least some agreement among all of us, which is that, it's not so much that we think that it's wrong for the court in some cases, or federal courts generally in some cases, to deny facial relief, but that, as Roger put it, it's sometimes very difficult to discern the pattern for when it does and it doesn't. And indeed, as both Steve and Eve mentioned, what exactly is meant by facial and as applied relief is sometimes unclear. That leads to the risk to which Steve earlier alluded of manipulation and something less than even-handed implementation. Second point, one that is specific, though perhaps not exclusively specific, to the voting context. It's somewhat ironic, I think, that voting and abortion are probably the 2 areas in which we've seen the greatest reluctance on the part of the court to grant facial relief. I mean, Eve's explained why in the abortion context that's problematic. In the voting context, it's really important that there be clear rules that are established in advance of an election. And we are especially concerned about the systemic impact of laws affecting participation, like voter identification laws, or like, for example, Florida's no-match, no-vote rule in the last election. And it may be difficult or even impossible due to mootness doctrines to litigate these things after an election. Third point, one that I think is particularly applicable or germane to Crawford, and is a lesson for lawyers, is that we need to be very careful about the cases that we take before this Supreme Court. I have to say, I was pretty clear from the moment the court granted cert that this case was not going to be decided in a way that was favorable to my perspective, which is I'm not a big fan of these voter ID laws, and I was actually worried that the court was going to make worse law than it did. I'm a board member of the ACLU of Ohio and was an ACLU lawyer for 8 years, but I think it was a big mistake, notwithstanding the awful decision below by Judge Posner for the Seventh Circuit upholding Indiana's law. I think it was a big mistake to take that case up.
Paul.
So what do we do? Just wait for a new Supreme Court? I mean,
On some issues, yes.
Well, that's going to be a long time coming, and meanwhile, rights still have to be vindicated. I mean, how terrified can litigants be? All of you can speak to this.
And look, just one more point on Crawford. I know the record wasn't as bad as the Supreme Court made it out to be, but it could have been, in my judgment, a lot better. And at the very least, I would have probably waited to seek cert in a case with a better record.
Weren't there other cases working their way up with better records, challenging other states?
I think the Georgia case may have had a better record, although the law wasn't quite as bad as the Indiana law.
Roger, I hear you wanting to say something.
Yeah, well, you, after I got through calling for facial challenges to statutes of the Lopez and Morrison sort, you asked Steve, Steve, you spend most of your time defending statutes, and you gave Section 5. But, of course, those kinds of cases are different. They involve federal and state litigation oftentimes in the name of some right holder at the state level. And so it's not the same as a Lopez or Morrison kind of case. And so I would, in most of those kinds of cases, be on Steve's side, because that's what the 14th Amendment is for, or the Voting Rights Act, for that matter. Indeed, that's one of the issues that's coming up in Namudno.
Steve?
Yeah, I think this is what's known as a point of personal privilege. But Dan raises a very serious issue, obviously, which is not limited to the Crawford case, and it's a different challenge of constitutional litigation, and that is, when do you file cases, and how long do you continue to appeal in a judicial system that you think may not be sympathetic to your rights? And that's a question that constitutional litigators have to think about, litigators in general, but for purposes of this panel, constitutional litigators have to think about all the time. The short answer is not an answer to Crawford, but the short answer is that in the vast majority of cases in which the ACLU winds up in the Supreme Court, and the ACLU participates in more Supreme Court cases than any other private organization, in the vast majority of cases in which we find ourselves in the court, we are there as respondents. We are not there as petitioners. And we're there as respondents because we won in the court below, and the other side has typically a governmental entity of one sort or another has sought Supreme Court review, and the Supreme Court has granted cert. So then you have a different level question, which is, well, do you stop taking cases at all? Because if you win in the lower court, the losing side may take it to the Supreme Court. That can't be the right answer, because we all know the vast majority of cases never get to the United States Supreme Court. So some of it is kind of a roll of the dice, and some of it is beyond your control. In the particular context of Crawford, I will say it was the subject of a great deal of discussion. We were represented a set of parties. The Indiana Democratic Party was involved in the case, separately represented by counsel. We talked to a lot of people around the country who had conflicting views about the desirability of seeking cert. But when we ultimately decided to go forward, we decided to go forward because this case didn't exist in a vacuum. And what was happening was there were a series of other ongoing litigations in the country. We were reasonably confident that the issue was going to make its way to the United States Supreme Court, because in addition to the ongoing litigation, there were also a handful of, if not more, state legislatures that were considering enacting copycat bills. And the judgment that we made, right or wrong, I mean, we engaged in exactly the same exercise that Dan was just describing, which is we looked at the strength of the record and we looked at the severity of the law. And perhaps the record could have been better. Most people, however, agree that the law was the most onerous law in the country. And so we then simply decided the issue was going up one way or the other, and we thought this was a better vehicle than any of the other cases in the pipeline. Now, that may have been the wrong judgment, but that was certainly a serious discussion that we had before we pulled that trigger.
So I want to have some time for audience questions, but before we do, I want to ask you all one question, which is, so what about state courts? We've been hearing for a generation, in particular ever since Justice Brennan's influential essay about the importance of state courts in promoting and defending both federal and state constitutional rights. Why, is that an attractive option? Is it an attractive option that people will be turning to more, or are there reasons why we've been mostly talking all day about federal pleading standards and federal justiciability rules. And any of you can start.
Depends on what state you're in.
Right, yeah.
Yeah.
Uh-huh.
Yeah, I'll start because that was actually what I was thinking as Steve was talking. I mean, obviously, a lot of what we've been talking about are challenges to federal laws, and so federal court seems like the more obvious, if not the only route. But certainly in the area that I practice in, where we're challenging for the most part state restrictions on access to reproductive health services, we look first to the state courts. Exactly for these reasons that we just don't want it. There's virtually no case that I would want the Supreme Court as it's currently constituted to grant cert in the area I practice in. So if there's any chance that we think that we can win the case in state court, I mean, if it looks the same between federal and state court, we're going to state court. Obviously, if it looks better in state court, we're going to state court. It does. I mean, there are some disadvantages to state court. Is that even in the states where we think that the Supreme Court, that we have a good shot of winning the case, often the trial level courts where the judges are more often elected and the elections are more often highly politicized, we think that we have a much harder shot of getting a temporary injunction or preliminary injunction in the state courts than we do in the federal courts. But often, that's something that we're willing to deal with, looking down to the potential of getting a good state Supreme Court ruling. So I think it's definitely a promising area, though as Dan said, I mean, there's some states where it's, for us at least, it would be pointless.
And is the decision usually made to pursue a state constitutional claim or both a state and federal constitutional claim? How does that work out from a practical?
We would only bring state constitutional claims in state court, because if you bring the federal constitutional claims, the Supreme Court could still grant cert. So we don't want to.
Or in some cases, it could be removed.
Yes, right.
Paul, you asked whether a state court is an attractive option. And I think it was Dan who said depends what state you're in. It also depends what your agenda is. I'll give you the case of Wyeth v. Levine. You may recall that's the case of the Vermont woman, musician, who lost part of her arm as a result of a procedure for administering a particular drug. The labeling of the drug was established by the FDA for a uniform national standard. And it was clear on the label that there was a warning that there was an alternative procedure for administering it that was extremely risky but had benefits. In other words, the question was, what is the notice, and is it clear so that the person doing the administering, in this case the nurse, knows the red risk, and it's then up to that person to decide whether to approach the risk for the benefit or not. Well, in this case, as you probably know, the risk was taken, the untoward event materialized, and she lost part of her arm. It went before a state jury, and of course the state jury, seeing only the sympathetic plaintiff, not all the people who had benefited from the administration of this particular risky procedure, found for the woman. And it went all the way to the Supreme Court, and the Supreme Court did as well. I think it was a 5-4 decision. And it raises the question of what are the rights, respective rights, of the parties in this situation. To be honest, with respect to the pharmaceutical company, it doesn't matter where you draw that line. It's just that they need to know where to draw it. If you draw it under the Commerce Clause, which was designed primarily to ensure the free flow of goods and services among the states, and therefore not to require, in this case, 50 different labels for 50 different states, then at least it serves to give notice about the rights and respective obligations. In other words, the pharmaceutical company knows where its rights are, the user knows where. If you allow state juries to change that, then you're going to have a complete if I may say so, chaos in the administration of this risky matter. Again, there's no, in this matter of determining where the rights are, this is a line drawing matter, as in all risk cases. 50 miles an hour, the speed limit, you could have it at 10 miles an hour and have a lot fewer deaths. You could have it 80 miles an hour and have more deaths. We draw it at a certain point. Here we did the same thing. She approached the risk, knowing what it was. It materialized. Then she wanted a second bite of the apple. That's why I think that preemption is the proper issue here. And, of course, when you're talking about state court, you're talking about it in conjunction with various preemption regimes.
And I'll just make two very quick points about state court. One is it's not only the state, it's not only the issue or the agenda. You also have to take a look at the procedural rules, so that in New York State, where I practice and which I know best, there are virtually no bars on interlocutory appeals. And so the case can be taken up piecemeal, and you bounce back and forth between the trial court and the appellate court. And when the government appeals an injunction against it in New York State court, it is entitled to an automatic stay of the injunction. And so, there are procedural reasons why you may want to be in one court as opposed to another court. And then the single most prominent contemporary example of a very deliberate national strategy to pursue a right in state court rather than in federal court has been the litigation around gay marriage. Now, there has just been a federal lawsuit filed that has been very controversial, but until that point, the decision that was made by the sort of advocacy community that was involved was that the Supreme Court was not yet ready to take on the issue of gay marriage. It was too risky to bring the issue to the Supreme Court at this point, that it was important to build up a body of state law, either politically through the legislature or judicially through the courts, sanctioning gay marriage before going back to the Supreme Court and asking them to decide it as a federal constitutional matter. So there are circumstances in which people do make that judgment, Paul.
Thanks. We have a little bit of time for audience questions if we have one. Yes. If you could stand up when you're asking a question. I don't think we have a mic out there, but try to. Oh, we do. Great.
As a litigator, I'm concerned about the fuzziness of the distinction between the facial and the as-applied challenges, and particularly about the way in which that fuzziness is susceptible to results-based manipulation of the kind that this panel has been pointing to. I'm wondering, though, specifically about Steve's example about the as-applied challenges being kind of taken as requiring plaintiff by plaintiff exemptions, as opposed to a more sort of fact pattern-based as-applied exemption that we're used to, and, for example, the as-applied challenges to BICRA. Are there particular cases that you're thinking of when you're thinking of, does as-applied challenge mean that you have to keep bringing these cases on a litigant-by-litigant basis?
No, I think we all, just as Eve was saying after reading Carhart, the lawyers who litigated that case were scratching their heads about what they had to do next. I think likewise, when the court said bring an as-applied challenge in Crawford, as you know, they didn't say because these are the issues that we want, to have adjudicated. These are the facts that we think are necessary to resolve this case. They just sent it back for as-applied challenges without explaining what that means. And so I don't, I don't know.
But go ahead.
Yeah, I mean, I think that's right, and I guess I would say, we can't be the rule, can it? That every single potential voter, for example, who thinks that he or she is unfairly burdened has to go into court separately. I mean, courts, have to base their rulings on principles, and when a court makes a holding as to a particular individual, this ID law, let's say as to homeless people, may be unconstitutional. I mean, presumably it will apply to others, but I think it is certainly true that we don't really know, at least in my area, what this means yet. And one wonders, if you think back to Harper versus Virginia, the poll tax case, would the court say that every single person who thinks that the poll tax is an unfair impediment to the right to vote has to go in separately? I mean, I would hope even this court wouldn't say that, but seems to me hard to square the court's ruling in Harper, which we would, I think, almost all view today as striking down the poll tax on its face. Hard to see how that squares with the jurisprudence such as it is.
Isn't
But in Gonzalez, the court specifically said that the next challenge should be as applied, and it could be a pre-enforcement as applied, which raised the question that I raised earlier: what is the difference between a pre-enforcement as applied and the pre-enforcement facial challenge we brought, other than potentially the remedy? But of course, the court always has the power to craft its own relief. So
right, and I think the assumption is that there may be some middle ground, whether it's pre or post enforcement, in which you can bring categorical challenges. Right, everybody who shares the same common characteristics. Yeah. The problem is, in the abortion context, everybody's medical condition might be slightly different. In Crawford, everybody may have a slightly different reason for why they can't obtain a certified copy of their birth certificate from their home state. And then we get into the class action world, right? What is typicality?
And another problem is that we may run into other doctrines like ripeness and mootness, making it difficult to get into court at all on some kinds of claims.
Another question. Yes. Nope. Yeah, wait. If you can use the mic, that'd be great.
Hi. My question is basically one sort of looking at after the Heller decision and the emergence of, I guess, gun rights litigation. If you think that sort of the normal roles of the conservatives in the court using standing justiciability, facial versus as applied challenges to basically bar the courthouse door from progressive groups, with the sort of shoe being on the other foot, will this force consistency, or will this just create an even more muddled, results-oriented approach to these issues?
I think that's a softball. No. Any of you?
Let me just look. I mean, if one is a liberal thinking strictly for pragmatic purposes, we might actually think on balance that a rule making it more difficult to bring facial challenges is, if even-handedly applied, a good thing. See Heller, see the Namudno challenge to Section 5 of the Voting Rights Act. The concern that I have, at least, is that it's not going to be anything close to even-handedly applied, and whatever your ideological perspective, going back to points that were made earlier, we've got to have some more guidance coming from the court, I think, as to what's the pattern here, under what circumstances are facial challenges appropriate, what circumstances aren't they appropriate.
Maybe one more, yes.
Dan, I know in your home circuit recently there's been a trend toward certifying more cases to the state Supreme Court for answers. And I wonder, to all the panelists, what your thoughts are in terms of that procedure. Are they using federalism as a dodge? And what effects does it have on your ability to litigate the cases fairly and efficiently?
I defer to other people on this one.
Yeah, I mean, we actually have a case that was just certified to the Ohio Supreme Court. I look at it from a completely result-oriented way, which is that if it's a good Supreme Court, we're happy with it. But on the whole, I don't think it's completely crazy to get definitive interpretations of the meaning of statutes from the state court. That's a radical.
Of course, one
position
problem is usually it's only the Court of Appeals that can certify a question to the state Supreme Court. So very often you have to sort of go through a whole round of litigating something without having a definitive interpretation, and then you find yourself in the circuit court, and then somebody comes up with the great idea of let's certify it.
Right. I'll actually throw out just another kind of constitutional wrinkle. We do a lot of litigation in the state of Missouri where there is no certification process. And so what happens repeatedly in our litigation in Missouri is that we bring a federal court action, and then often the state has brought a separate state court action seeking the meaning of the terms of the statute that we're litigating the constitutionality of in the federal court. And so we have this kind of, at least two-ring circus going on simultaneously. So, I actually think that, the certification process can be useful.
Yeah, I will just say, and this may be a generic comment, that one of the things that is frustrating as a litigator is the number of hurdles you have to jump now before you get to reach the merits of some very important constitutional questions, win or lose. There's just an enormous amount of time spent litigating these issues, which have a function, and I don't mean to say that they're unimportant, but they have become really dominant in constitutional litigation in a way that I think was not true when I began my career.
Well, I want to thank the panel very much for a lively discussion. And speaking of hurdles, I want to invite everybody to go to the Constance Baker Motley Moot Court Competition final round, which is coming up immediately after this panel. And the reason why I say speaking of hurdles is that the two issues in that moot court competition are the state secrets privilege and Article III standing concerning a challenge to the terrorist surveillance program. So all the things that we're talking about are going to be very much on display in that moot court competition. Thank you very much. I thought it was terrific.